Hello and welcome to today's presentation of the FERS Law Enforcement and Firefighter Special Retirement Provisions. I'm Phil Gardner with the Office of Personnel Management, Benefits Officers Training and Development. Today we will talk about FERS Law Enforcement and Firefighter Retirement Provisions. We're going to stick with FERS. CSRS is sort of going by the wayside nowadays, so we will stick with FERS. So hopefully at the end of today's session, you should be able to understand the LEO and firefighter rules for position coverage under FERS, learn the rules for LEO and firefighter retirement eligibility, learn to certify eligibility at the time of retirement, and today we're also going to go over some basic annuity computations. First, your references for today, the CSRS and FERS Handbook Chapters 46, which is Special Retirement Eligibility, 50, which is annuity computations, and 51, which is annuity supplements. Then also Benefits Administration Letter 10-105, and then 5 United States Code 8401, 14, and 17, those are definitions, and 8412D, and also 5 CFR 842 Subpart H. We're going to start by going over some basic definitions that are used in the determinations of firefighters and law enforcement officers. First, let's talk about a FERS law enforcement officer, and that is an employee whose duties are primarily the investigation, apprehension, or detention of individuals suspected or convicted of offenses against the criminal laws of the United States or the protection of officials of the United States against threats and personal safety. And this differs from the old CSRS definition, they're sufficiently rigorous that employment opportunities are limited to young and physically rigorous individuals as determined by the director of OPM. First line supervisors may be considered to be a rigorous position if they meet those definitions. And then a FERS LEO also includes an employee who moves directly from a rigorous to secondary position after performing primary and rigorous duties for at least 3 years. We will talk about that in detail a little bit later. It's called the FERS transfer requirement. FERS LEO definition, it also includes employees whose duties are in connection with individuals in detention suspected of offenses requiring frequent, direct contact with these individuals and are sufficiently rigorous. So we're talking about essentially detention officers in a correctional facility, in a federal correctional facility. It also includes an employee of the Department of Interior or Treasury, now DHS, who occupies a position that would have previously been subject to the District of Columbia Police and Firefighters retirement system had FERS not been acted. And these are generally, we're talking about Secret Service officers and U.S. Park police officers. The definition of FERS LEO, it does not include maintaining law and order, protecting life and property, guarding against or inspecting for violations of law, or investigating persons other than those suspected or convicted of offenses against the criminal laws of the United States. So essentially, it does not include what we would consider a basic police officer or a basic security guard. Next, let's go to the definition for a FERS firefighter. So a firefighter is an employee, the duties of whose position are primarily to perform work directly connected with the control and extinguishment of fires, and are sufficiently rigorous that employment opportunities be limited to young and physically rigorous individuals as determined by the director. We'll talk about this in a little more detail about the young and the actual definition of rigorous and some other associated things with that. FERS added that rigorous definition to both the law enforcement officer and firefighter definitions. That was not previously in the CSRS definitions. It also includes an employee who moves directly from a primary to a secondary position after performing primary and rigorous duties for at least 3 years. That's what we refer to again as the FERS transfer requirement, and we will be going over that in more detail. It does not include the maintenance or use of firefighting apparatus, and it does not include routine fire preventions and prevention inspections. Primary duties, that's a term we've thrown out a couple times. And primary duties are just those that they are the paramount influence or weight. Essentially, it's the reason that position exists. And it would occupy the substantial of an employee's time, and that would be, say, 50% or more over their typical work cycle. And it's assigned on a regular and recurring basis. So it does not include emergency details, incidental duties, temporary duties, even if the substantial portion of that time, in other words, even if the person's doing it 50% of the time, if it's not their basic job, essentially, then we're saying it's not going to be considered a primary duty. A rigorous duty are duties that are so rigorous that employment opportunities should be limited to young and physically vigorous individuals, and that's as determined by the director of OPM, considering the recommendations of the employing agency. So essentially what we're talking about is through the establishment of a maximum entry age and with physical qualifications. The maximum entry age is generally 37, however, there are some exceptions for certain veterans. Now we'll talk about a secondary position. A secondary position is one that is clearly in the law enforcement or firefighting field. It's in an organization that has primarily a law enforcement or firefighting mission and is either supervisory or administrative. And we will actually talk about what supervisory and administrative exactly means. So supervisory position, that's a first level supervisor of an employee in a primary or rigorous positions. It can be considered to be a primary rigorous position, a first level supervisor. As we said earlier, it may be primary and rigorous if it meets those conditions. But if it doesn't, it can still be considered covered as long as it's a supervisory position in that field, okay? And the first level supervisors do not have a subordinate supervisor. So in other words, there's no other supervisors in between that supervisor and the employees to be considered a supervisor. Administrative duties, these are executive duties, management duties, technical, semi-professional, or maybe a professional position, but you have to have experience in either a primary or a rigorous position or equivalent experience outside the federal government, and that would be a mandatory prerequisite to be able to take that job. Now, I would like to point out that if someone qualifies for a secondary position through using, say, military experience or using non-federal civilian experience, that means they may qualify for the position, but they would have to meet the FERS transfer requirement, which we'll talk about shortly, to have coverage. Next, we're going to talk about detention duties, and I think that's pretty clear what detention duties are, but it are duties that require frequent and direct contact in the detention, the direction, supervision, inspection, training, employment, care, transportation, or rehabilitation of individuals who are suspected or having already been convicted of offense against the criminal laws of the United States or the Uniform Code of Military Justice. So essentially here we're talking about a prison guard, essentially, and they're either directly involved in direction, the detention, training training the detainees, transportation of the detainees, rehabilitation. Okay, so that's detention duties. And then when we talk about frequent direct contact, we're talking about personal, immediate, and regularly assigned contact with detainees while performing those detention duties that are repeated, and it's continued over a typical work cycle. So it wouldn't be someone who maybe gets called in to do something temporary involving prisoners. So we're talking about frequent direct, it's personal, immediate, regularly assigned, and again, it's their primary function in their job. Now you might hear a term thrown around called within the walls. And essentially what within the walls says is that most employees in a federal prison or detention facility are considered within the walls and are considered to be or can be considered to be LEOs under the detention provision, because they are trained. They are trained to deal with situations and must have essentially the same qualifications as the actual prison guards or someone transporting prisoners would. Next, we're going to talk about what the definition of an agency head. So the head of an agency, the agency head, it's considered the head of an executive branch agency that's defined in 5 United States Code 105. We're talking about an executive department, a government corporation, or an independent establishment that is considered part of the federal government. We're talking about the head of a legislative branch. That would be the Secretary of the Senate, Clerk of the House of Representatives. In the judicial branch, it would be the Director of the Administrative Office of the U.S. Courts. In the Postal Service, it would be the Postmaster General. And that agency head can be deemed to include a designated representative of an executive department as defined in 5 USC 101, but it must be a department headquarter level official who reports directly to the executive department or deputy department head and who is the sole representative for that entire department. The delegation of that agency's head authority to approve positions as a primary or rigorous or secondary position is only allowed in the 14 cabinet-level departments in the government as listed in 5 USC 101. So we're talking about the Department of Interior, the Department of Treasury, Department of Homeland Services, the Department of Defense, that kind of thing. It does not include the head of a component of the agency. So for instance, Department of Defense, that department, the Secretary of Defense can designate the Secretary of the Army, but the Secretary of Army could not designate anyone below that individual. And now for the purposes of denial of coverage, the agency head can include that designated representative of an agency head, pretty much at any level within the agency. Going too fast. Okay, so now we're going to talk about the actual coverage and determination process. We're going to be determining whether employees are covered by the special retirement provisions or not covered. So coverage requests, they can come from several different places. A position coverage request can come through the agency. The individual position coverage request can come directly from an employee. And under FERS, an individual could request coverage for past service or get past service credit. That is not provided, however, under FERS. So under FERS, you cannot request coverage for a prior position or credit for a prior position. So let's first talk about primary position approvals. So prior to 1993, OPM had the responsibility for position approvals. Agencies would send the requests for position approvals to OPM. OPM had a group that actually did nothing but determine whether a position qualified for law enforcement or firefighter. And in 1993, we delegated that authority to the agencies. We retained an oversight function, but we delegated the actual approval to the head of the agencies. So final approvals are made by the agency head. And again, that has to be that actual head of the agency, except in those 14 cabinet levels where they can designate one level down. Denials are made by the agency head or his or her designated representative. So for denials, the requirement isn't the actual agency head. Determinations for a primary position approval is based solely on the official position description and any other official descriptions of duties and qualifications required for that position. Secondary position approvals, again, the final approval has to be made by the agency head. Now, in both primary and secondary positions, the recommendation can come through the agency, say from a bureau into the director's office. They can make the recommendation, but that final approval has to be made by the agency head. And again, denials of secondary position approvals, they're made by the agency head or the designated representatives. Determinations are also based on the official position description and any other official description of the duties and qualifications, just like the primary. However, they can also use any other evidence, such as the nature of the experience required for appointment to the position, maybe some specific duties that they do that meet the criteria. And then we have what we call individual requests for position approval. And under FERS, the individual request could actually be made at any time. Under FERS, however, an employee must make their request for a determination for position approval within the first 6 months of entering that position or a significant change in their position. And if the employee does not do so in that first 6 months, then we deem that the agency head's determination that the position is not a covered law enforcement or firefighter position to hold weight. In other words, if that decision's not made in the first 6 months, if the request isn't made in 6 months, the person is determined not to be in an approved position. If a person does ask for a position approval within that first 6 months, the agency has to issue a written response. It has to be a written response from the agency head in terms of an approval. However, they may appeal the final decision to MSPB. The denial must be made by the agency, or it can be made by his or her designated representative, as we discussed earlier. So the agency head may extend the filing time if the individual can show that he or she was prevented by circumstances beyond their control from making the request within the normal 6-month time frame. If approved, that coverage is going to apply to any and all employees holding that same position. And if approved and the PD does not support approval, they're going to have to revise the position description so the position will have to be reclassified or the individual duties changed as appropriate. And so if there's any past qualifying service that was used for the approved position, that past qualifying service will be deemed to be service in an approved position. So when we talk about an employee requesting decision that their position is covered, the employee bears the burden of proof. It's not up to the agency to prove whether the person's in that position or not. The employee must provide the agency or their former agency with all pertinent information concerning those duties performed. So for a law enforcement official, they would need to provide a list of provisions of criminal laws the incumbent was responsible for enforcing, the arrests that they made, the investigative reports they filed, whatever duties and provisions of the primary or secondary coverage that they think qualifies them to be covered, they have to require all of that information. For a firefighter, they would have to actually provide the information of the number of fires fought, the names of the fires fought, the dates of the fires, and the position occupied while on firefighting duty. And they would have to show, essentially, that that was their primary purpose in their job. The same thing with the LEO. They would have to show that although they weren't considered a covered LEO or a covered firefighter, that was the primary job that they were responsible for doing. Okay, let's move on to agency responsibilities. So the agency, as we said, is responsible for making these determinations, not OPM. The agency is now responsible for making the determinations of coverage. And then once they've made approvals, they have to report all position approvals to OPM with the title of the position, the number of incumbents of the position, whether that position is primary or secondary, and they have to report that to OPM. And the address here to report it to is OPM, Associate Director for Retirement Services, 1900 East Street Northwest, Washington, D.C., 20415. So again, they must report all position approvals to OPM with that title of the position, the number of incumbents, and whether that is considered a primary or secondary position. They also have to keep a file of all requests that have been made, all determinations they've made, and any and all background material used to make their decision. Also, all determinations affecting an individual's coverage, such for a law enforcement officer or firefighter, must be filed in the permanent or the right side of the employee's EOPF, and I suppose there's a permanent section of the EOPF, so wherever that would be, it has to be kept in the official permanent side. And then upon request, if OPM requests information, the agency has to provide us a list of all approved positions and any other pertinent information that we may request. And you would need to be able to make available to us the entire coverage determination file for OPM to be able to audit to ensure compliance. So any background evidence that was used, any secondary evidence, the position descriptions, the qualifications required, etc. If we request it, everything has to be submitted to us. So OPM's responsibilities, as I said, we maintained oversight responsibility for the program. So whereas we delegated the responsibility to make the position determinations to the agencies, we maintained the oversight. And we keep a file of all approved positions. So when you send us that information for any of your approved positions, we keep a file of those positions and periodically reviewed. And we can actually revoke the agency decision except for certain employees performing detention duties, and that would be employees of the Customs and Border Patrol. It would include the Army, Navy. It would for field services of the Army and Navy, disciplinary barracks, or any other confinement or rehab facility of the United States military service. It would also, we cannot oversight, we can't do for a United States Secret Service officer or a United States park policeman, okay? But any other thing we can look at. And what we call that, if we received information, for instance, that would call into question whether a position should be covered or not, we call that an oversight review. And then we would review all that information in the folder and then issue a determination as to whether the position would still qualify for coverage or whether it would be revoked. Okay, so we've talked now about the determinations of coverage. You've seen how the definitions we went through earlier apply to all of the various coverage process, determination process. So now we're going to talk about service credit rules. So first of all, retirement contributions. So an employee serving in an approved, covered firefighter LEO position, they must have an additional 0.5% retirement contributions withheld. So for CSRS, that would be 7.5% instead of 7. For FERS, 1.3%. For FERS RAY, currently 3.6%. Or FERS FRAY, currently 4.9%. Oh, and I wanted to mention while we're on retirement contributions, if the proper retirement coverage is not listed, this is not considered a FERCA error. This is a mandatory correction. Being in one of the positions requires that extra 0.5% is withheld, and if it's not withheld, it must be withheld retroactively for wherever periods it covers, and it would have to be corrected prior to processing a retirement request under this program. So the service all has to have the appropriate 0.5% retirement contribution withheld. The employee's position of record is going to determine whether that service is covered under special retirement provisions or not. Okay, so if someone's detailed, for instance, from a covered position to a non-covered position, during the period of time they're in the non-covered position under detail, they're still covered by the special provisions. And conversely, if an employee is not in a covered law enforcement or firefighter official position, and they're detailed to one, they're not going to get coverage unless they were to actually be reassigned to that position and then be qualified for the position. Okay, so if you detail from covered to non-covered position, you maintain your firefighter or law enforcement coverage. If you're detailed from a non-covered position, you do not gain firefighter or law enforcement official coverage. Let's talk a little bit about FERS non-deduction service. So service not subject to FERS performed prior to 1/1/89 can be creditable for both eligibility and computation only if, when I say eligibility, I mean eligibility for retirement, only if the position is approved and the employee makes that deposit equal to the percentage that would have been withheld, or 1.3% of basic pay plus interest. Service that is in a I did want to point out while I'm non-deduction service, that service under non-deduction service can be used to qualify for the FERS transfer requirement. It can be used to qualify a person for a secondary position, okay? But that doesn't change the fact of whether it's actually creditable in the computation or for eligibility towards a benefit. I just wanted to point out that distinction. Similarly, service performed under other retirement federal systems is service in an approved position performed under another retirement system, such as Foreign Service or Tennessee Valley Authority. If it's an approved position, it can be creditable under FERS. The employee must take a refund of those retirement contributions and otherwise waive benefits first. Then they would have to pay the appropriate for deposit for a service performed, and just like the non-deduction service, they can only pay for that service performed prior to 1989. There are two exceptions, but I do also want to point out that service in another federal retirement system, even if it's performed after 1988 and doesn't meet one of the two exceptions we're going to talk about in a minute, it can still be used to qualify someone for their secondary position or to meet the transfer requirement. And then there's two exceptions that I referred to. That would be service performed in an approved position. Again, it still has to be an approved position, creditable under the Foreign Service Pension System, which is the Foreign Services FERS type program, or the Federal Reserve Bank Plan, okay? And in those instances, that service performed after 1988 is also creditable, and as long as, again, the employee takes a refund of the retirement contributions, otherwise waives their benefit, and pays the deposit equal to prevailing FERS rate, which is currently 1.3% for law enforcement officers and firefighters. Now, I want to make a mention of this. There is a difference between these other federal retirement systems. Some are contributory. That means the employee actually contributes. Some are non-contributory. Employee does not contribute. Under FERS, if it's a contributory position, even if they have to take that refund, that does not qualify as refunded service under the National Defense Authorization Act of fiscal year 2010. It's still treated as non-FERS service, and the deposit is paid, not a redeposit. Okay, let's talk about that FERS transfer requirement. So when we talk about a transfer requirement, we're talking about when someone goes from a primary rigorous position to a secondary position, and that is to retain their coverage, their special coverage that entitles them to special retirement. They must move directly, and when we say directly, you can have a break in service, but it cannot be more than 3 days. So they must move without a break in service exceeding 3 days from a covered rigorous/primary position to a secondary position. And this was added into FERS. This was not part of the SERS transfer requirement. They have to complete 3 years of service in a rigorous position, and that can include service during which no FERS deductions were withheld. So even if that service isn't necessarily creditable because it was performed after 1988, it can be used to meet the FERS transfer requirement. You must be continuously employed in a secondary position or positions since moving from your primary position without a break in service, again, exceeding 3 days. And there's one exception to that rule. And when we look at whether a service is continuous for the secondary requirement, we don't count a break in employment that was based on an involuntary separation, not for cause. And we use essentially the same criteria that would use to determine if an employee is eligible for a discontinued service retirement under 5 U.S.C. 8414B. Okay, so the 3-year rigorous service requirement. It must be an approved rigorous primary position. Again, retirement contributions are not required to be counted in terms of being in the 3 years rigorous service. Okay, so the temporary service can be used, intermittent service can be used, post-1988 temporary service can be used, service performed under other retirement systems, even after 1988, can be used to meet the 3-year rigorous service requirement. That's not going to necessarily make service creditable if the deposit's not paid or service after 1988, except for FSPS and Federal Reserve Bank Plan service. Primary service under FERS. So again, and we're not going to talk much about FERS today, but we will have a few mentions of FERS. So if someone had primary service under FERS, it can be counted. And that employee who elects FERS or automatically is covered while in a FERS secondary position, they're deemed to have already met the 3-year rigorous requirement unless there's more than a 3-day break occurring immediately before the election or automatic coverage, okay? Except for an involuntary separation, not for cause, the same type that would qualify someone for a DSR. So I'm going to briefly touch on the FERS to FERS rules. Credit for FERS under FERS definitions performed before the date an employee becomes subject to FERS is used for both length of service under FERS for retirement eligibility and mandatory separation. Also, an employee who meets the direct transfer requirement under FERS, they are considered to have already met the FERS direct transfer requirement. Now, this could be important if the employee was later separated and then returned to a primary position, so that they may have had a break for secondary purposes, but if they return to a primary position, they would only have to stay in that primary position for, say, 1 day and move to a secondary because they would have already met the FERS transfer requirement. And then any employee became covered by FERS while serving in a secondary position under FERS, they can have that FERS and that FERS primary position counted as service in a rigorous position for the purposes of the 3-year requirement, should they ever need it. So again, should they be separated and then come back in a primary position under FERS, they would already be deemed to have met the transfer requirement if they went back to a secondary position later. So an employee with a break in FERS coverage exceeding 3 days immediately before coming subject to FERS is not considered to be continuously covered in a secondary position. And again, we don't count as a break in coverage if that break was for involuntary separation and not for cause. And I would like to point out that the agency head or his designee is the person who makes the decision as to whether someone's involuntary separation is excluded for purposes of the continuous coverage rule. So if someone has more than a 3-day break of service, but it was an involuntary separation, the agency head or the designee makes the decision if that's considered one of the exceptions. And again, it's based on essentially based on the FERS DSR criteria. We'll quick talk about military service. Generally, military service cannot be credited as law enforcement officer or firefighter service. Now, we said it can be used potentially to qualify someone for a secondary position, although they might not meet coverage rules to be covered in the secondary position because they might not meet the FERS transfer requirement. But military service can be used if it interrupts the employee's career in an improved position, and it can be used for eligibility, computation, and even mandatory separation purposes if they exercise their restoration rights to their position, to their law enforcement officer or firefighter position, and then pay their post-56 military service. So, for instance, if someone, if an employee went on separated from military, came back, restored used their restoration rights to their position, that 3 years that they were on military and paid their deposit, that 3 years they were on military could be used to meet the 20 years required for the special retirement. And we're going to talk about retirement provisions, retirement eligibility in just a few minutes. We'll touch on reemployed annuitants. So a retired law enforcement official or firefighter who was retired on a mandatory separation, they are barred from reemployment in a primary position after reaching age 60. They're not barred, however, from any other reemployment or even reemployment in a secondary position. So, but a service by a reemployed annuitant is generally not covered by the special retirement provisions. Okay, the agency must withhold the required deductions, which is the additional 0.5%, because that goes with the position. Okay, but the supplemental annuity, for instance, would be computed just on regular supplemental annuity rules, because the person already has their 20 years at the higher accrual rate. Or if it's a redetermination annuity, they already have their 20 years, so their annuity is already going to be recomputed as a firefighter or law enforcement official. So I just wanted to touch on that. And finally, let's talk about the certification requirement. So BAL 10105 required certification of law enforcement officer and firefighter service upon separation, any separation from a covered, special covered position. Okay, it doesn't necessarily have to be just a retirement. It's any separation, just a resignation, a termination, whatever it is, requires that the 10105 certifying that period of service be completed. So the certification, it lists in chronological order the title of each position, beginning and ending date of the service in each position, the length of the service in each position, the position description number that the service was performed under, the location where the service was performed, and the special population code, which essentially indicates whether coverage was primary, rigorous, or secondary. Okay, that form RI 20-124 was published in September 2012, and we did this to provide uniform certification of the service so that we would get each of these details that we wanted, the position description number, the length of service in each position, the location of service, the special pop code, and all that. Okay, so the form has been available since September 2012, and there is a BAL in process to announce requirement of the use of the 20-124. But this is going to essentially replace the old certification letter that you used to have to do when an employee was retiring. And that form would be filed in the permanent side of the OPF, or whatever the permanent section of an EOPF is considered, or submitted to OPM with all other certifications in the event of the employee's retirement or death. And we're going to talk a little bit about why the 20-124 and the certification process is required after separations from any covered position, any type of separation, when it used to only be required that a certification be done at retirement. We'll be talking about that shortly. Just wanted you to see what the form looks like and that it is available at opm.gov under forms. So the form is available. It should be used to certify the coverage upon separation, any type of separation from a covered position. Okay, now we're going to talk about retirement eligibility. Great graphic, huh? So we're going to concentrate on FERS. So under FERS, the type of separation is optional if the employee has 20 years of special covered service and is at least age 50, or has 25 years of covered service at any age, or mandatory retirement is applicable once an employee reaches 20 years of service and age 57. It has to be both, 20 years and age 57. And I wanted to note that an employee is deemed to reach their age on the day before their birthday. So essentially, the person's annuity commences on their birthday. FERS retirement eligibility. So they must meet the age and service requirements we just discussed. 20 years of special covered service with age 50, or age 20, or 25 years of covered service at any age. And I wanted to also mention that this can be used in combinations of service. So it could be a combination of law enforcement position and firefighter service, or and customs border protection officer service, or nuclear materials courier, or Capitol Hill police. So it can be a combination of different types of special coverage. This has to be 20 years in total of the special coverage. So once they have that, they must meet those age and service requirements that we talk about, but they also must be separated from a position subject to FERS. And remember, there's no 1 out of 2 requirement under FERS like there was in CSRS. And here's an important thing: they do not have to be separated from a covered position. So essentially, a law enforcement officer, firefighter, can leave a covered position once they've attained 20 years. If they're under age 50, they can leave that position, go to another type of position, a totally different position, non-covered, not covered under special retirement, and then once they hit age 50, they can then still retire under that special provision. So it does not have to be separated from a covered position. And just a note that unused sick leave cannot be used to meet that service eligibility requirement. It cannot be used to meet 20 years for age 50 or 25 years for any age. Talk about FERS mandatory retirement. So a firefighter or a law enforcement official, they are subject to mandatory separation on the last day of the month in which that employee meets both the age and service requirements. They have to be both at least age 57 and have at least 20 years of service. So if an employee is 58 but doesn't have 20 years of covered law enforcement or firefighter service or combined yet, they are still not required to be mandatorily separated until the end of the month in which they have both the maximum or both the 20 years and age 57. Now, I know you're thinking, if the maximum entry age is 37, how can that happen? Well, again, there are some exceptions to the maximum entry age. So if the employee is in that position and they are hired after age 37, or if they're rehired after age 37 and had some time, they could hit age 57 without having 20 years of service. Okay, but once at the end of the month they have both age 57 at least and at least 20 years of service, they must be separated. Now, the agency has to notify that employee in writing at least 60 days before the date of that mandatory separation. And the failure to do so is going to delay that mandatory separation. So if you delay getting someone the letter that they're being mandatorily separated, that separation can't be effected unless the employee agrees to be mandatorily separated earlier until the last day of the month after that 60-day period expires. So again, it is important that you keep track of this information of when an employee who is 57 but doesn't have 20 years of service yet, when they hit that 20 years of service, or an employee who already has 20 years of covered LEO or firefighter service. Keep track of, if they already have 20 years, when they hit age 57, so that you can properly separate someone for mandatory retirement. The mandatory separation requirement can be exempted up to age 60. It has to be done by the agency head. And it would generally be for requirements of the service, or to continue proper service or proper function of that office, whatever the requirement is, the reason why you need to exempt this person past age 60, the agency head can approve that. Now, under FERS, mandatory separation after age 60 must essentially be approved by the President of the United States by executive order. Under CSRS, those requests used to come to the director of OPM. Under FERS, however, it has to be an executive order to exempt someone past age 60 for mandatory retirement. And again, let's talk about that retirement certification. It used to be a letter. And now it's the RI 20-124, available at opm.gov under forms. and it's signed by a responsible official of the employee's HR or payroll or personnel office, and it has to list in chronological order the title of each position, beginning with the first law enforcement officer or firefighter position held by that employee and the beginning dates of the employee's service in each position. It should note whether it's supervisory, administrative. However, if you're using the form and it has that code on it, you can use the codes. And it has to be list the agency from which the employee is retiring and have, of course, all the employees' identifying information. And in the past, it used to be sometimes a little difficult to get that certification. If there were prior positions that were being used from a different agency and maybe there was no certification there. Now that we're requiring the 20-124 after all separations, that shouldn't happen as often now. Has to show the exact dates the employee occupied the covered positions, all the position titles, series and grade for the cover service, category of coverage for the person occupied, meaning primary, secondary, supervisory, administrative. But again, those codes that we talked about earlier would also indicate that. And then any individual service credit determinations that were made should be included in there. Verification that additional contributions were withheld. And again, if the proper contributions weren't held for any period, they have to be corrected and have to be submitted to OPM before we can process the claim. Any prior certifications that are in that OPF or any other prior 20-124 should be included with your package. And your package should be identified, clearly identified, as a law enforcement firefighter on the 3107-1 in Schedule D, Section A, Item 5. So that way we know we're looking at a law enforcement case. So I did add a section on computations, and we're not going to go into detail about how to do an annuity estimate. Most of you have programs now that if you indicate it's covered positions, excuse me, it'll do the computation for you. However, I just want to talk a little bit about annuity computations and about the annuity supplement. So a FERS special retirement computation is average salary times up to 20 years of LEO service times 1.7%. And then all remaining years and months of service is added at the 1%. And I'm going to say something here that I'm going to slightly contradict a little bit later. The 1.1% never applies to these standard LEO firefighter computations. So even if the employee is 62 years old at the time they retire, and has 20 years of service, obviously, if they're qualifying for the special computation, but the 1.1% will not apply. The 1.1% special provision for FERS employees at 62 with 20 years of service. So we talked about why that BAL came out and why we require the 20-124. So there was a series of court cases that changed how we have to calculate disability and survivor annuities for law enforcement or firefighting officials. We call it enhanced disability and survivor annuity computations. And if you've ever gone to the handbook to look up something about law enforcement officers and firefighters or disability and survivor annuities, you probably see the warning about this. So BAL 10105, dated July 10, 2010, provided information and guidance on how these things are done. So essentially, it allows 1.7% of average salary for up to 20 years of LEO and firefighter service, even when the employee does not meet the minimum qualifications. In other words, even if they're not age 50 with 20 years of qualifying service, or if they don't have 25 years of qualifying service if they're under age 50. So now, only on disability and survivor annuity computations, the 1.7% can be allowed for the service up to 20 years. So if someone only had 5 years of law enforcement service at the time they passed away, they would need 10 years, obviously, total of other service to total 10 years to have a survivor annuity benefit. But that 5 years could be allowed at 1.7%. In a disability case, that 5 years of covered law enforcement fire official service could be used at the 1.7%. This was a departure from the standard rules and regulations prior to that, which said you had to have the 20 years to get the enhanced computation. and the age. So now let's talk a little bit about the FERS special retirement average salary. So it's going to be just like any other retirement. It's going to be your highest 3 consecutive years of basic pay. But I just wanted to note that basic pay includes locality pay, and it includes premium pay, and that can be law enforcement availability pay, which we call LEAP, for law enforcement officials under 1811. It can be administratively uncontrollable overtime, or AUO as we refer to it. It is, however, subject to both a biweekly and annual pay cap of higher of the GS 15 Step 10 or Executive Schedule Level 5, which presently for Washington, D.C. is $160,330. For the rest of the U.S., it's $152,593. But depending on various different localities, there's various different scales in between that. Okay, so that is the cap in any biweekly pay period that a law enforcement officer or firefighter can receive, and that can be used for the computation of their average salary. Briefly, I want to talk about the FERS supplement. As you know, the FERS supplement approximates the Social Security benefit earned based on FERS creditable service. To be eligible for that supplement, the employee must have 1 full calendar year of deductions under FERS, and generally they have to be at their minimum retirement age and eligible for an immediate non-disability annuity for at least 20 years of service. There is an exception, however, and that is that a LEO or firefighter retiring under FERS Special, they're going to be eligible to receive that annuity supplement at retirement, even if they're not at their MRA. So they could be exactly 50 years old with 20 years of qualifying law enforcement service, and they would be entitled to an annuity supplement, even though they're not at their MRA, and that FERS annuity supplement is not subject to the earnings limitation until that retired law enforcement officer or firefighter reaches their minimum retirement age. So I just wanted to point that out. And with that, I think we're done. So I want to thank you for tuning in with us, and now I'm going to take some questions, and I just want to note that any questions we answer today, we're going to put out a Q&A document that'll go on the website along with this presentation when this is available for viewing on our website. And we'll also include any questions that come in after the webcast is over, or that we are unable to, due to time constraints, answer while we're on the air here today. So again, thanks for tuning in with us, and let's have some questions.
Phil, the first question would be, can you explain the Isabella ruling on the rigorous requirement? Would it be possible to hire a 62-year-old under Isabella?
Okay. You know, I'm going to defer that. First of all, I'm not exactly sure what Isabella refers to, unless that is the that may be the exception for veterans, where they determined that it sort of violated the veterans, was it whatever. There's a law that says that you know, veterans get their preference, and they determined that this would violate the tenets of veterans' preference. And to know, I know that in that situation, I think that's Isabella, someone can be exempted from the maximum entry age. I don't know, however, whether there are any limits on that maximum entry age, so I can't say yes, no. 62 could be still employed as a primary firefighter or law enforcement official. So I'm going to defer that part of the question. I'll do some research, and I'll have it in the Q&A.
Does this webinar address buying back your legacy time and putting it towards your law enforcement time?
Say that again?
They're asking whether legacy time, if you can address legacy time and putting that toward your law enforcement time.
Legacy time. Well, I'm not familiar with that phrase, so once again, I'm going to have to defer and look up exactly what legacy time refers to, and I'll put it in the Q&A. I'm sorry, I'm not going to fake an answer. If I don't know it, I'm going to tell you so, and I will do the research, and we will get it in the Q&A.
This one says our OIG office has requested a review of the 8111 series classification of their investigator and supervisor positions. What happens to current incumbents if they agree they should be classified as LES?
So when you say that they're looking at it, I first would have to know whether this is an agency decision to look at it, or if this is a request, an individual request for coverage within the first 6 months of entering the position. In an individual position request, the determination would apply to all service that qualified them to be considered a law enforcement official position and all persons serving in that position. If it's an agency-wide decision, I'm going to have to defer that, and I'm going to have a lot of research to do to answer these questions. I can see that right now. So I will do the research on that and provide a definitive answer in the Q&A document. I'm 0 for 3.
Can an employee who completes 20 years of law enforcement service but leaves federal service before turning age 50 still retire under law enforcement special retirement provisions after they return to a position with FERS after age 50?
Okay, so the question is, can someone return, in other words, separate from the federal government before age 50, but they already have 20 years of qualifying service, and then subsequently get a special retirement? And the caveat is they would have to return to FERS covered position, not necessarily a special covered position. Remember, once you have 20 years of qualified FERS, law enforcement, or firefighter time, then essentially you can retire. If you switch positions, you can retire once you hit age 50, etc. Okay, and that would be the same if you separate, but the deal would be you would have to separate with already having your 20 years of service. So you separated with 20 years of service, but obviously you weren't age 50 yet, so you weren't eligible for a law enforcement or firefighter retirement benefit. But if you return to a covered, and when I say covered, this time I'm going to talk about just a FERS covered position. It doesn't even have to be a special covered position. You could then retire at any point you're age 50 and have that 20 years of approved law enforcement firefighting or firefighting, or that combination that we discussed earlier. What you can't do, however, is subsequently apply for a deferred annuity and get the special comp. The comp you have to, remember, I think a few slides back we talked about you have to leave a FERS covered position and be eligible for an immediate annuity. So you would not be able to get the special comp in a deferred retirement, but you would be able to get it if you returned into a FERS covered position, not necessarily special covered position, because you've already got your 20. Now you just have to be at least 50 and be separated from a position covered by FERS and be eligible for an immediate benefit.
You mentioned department heads as the approving official in the determination processes. Can you clarify, in a scenario where the LEO is serving under the Office of Inspector General, it is my understanding that the Inspector General is the decision maker. Can you confirm?
Clyde, clarify that question for me. Did he say for a position approval?
It just mentioned determination processes.
So I think we mentioned several times during the webinar that only the agency head can make the decision for a primary or secondary covered position. They do so usually with the recommendation of, say, the Inspector General, if that's where the position is located. The package would come from there, but the final approval has to be the agency head. It can be designated down one level only in a cabinet level agency. Now, for other positions, for other determinations, for instance, a denial could come from the IG. A decision of whether the separation qualified as an involuntary separation, in other words, for the purposes of the FERS transfer requirement and continuing coverage during all secondary positions, could come from one level lower, but not the approval.
Next up, does time as a legislative branch LEO carry over into the executive branch as an LEO for calculating LEO retirement?
It can, yes. It can. The Capitol Hill Police have a unique distinction of being both considered law enforcement officials and congressional employees. So they have some unique calculations and such. But generally, it can be combined with law enforcement official service from elsewhere. Yes. Kind of off topic, and has anyone noticed that this person seems to have 5 thumbs in the questions? I'm just saying.
Okay, next up, are there any special provisions for presidential appointees who are covered under FERS special retirement coverage, or are they treated the same as regular LEOs?
Well, in terms of LEO retirement, in terms of coverage rules, computation rules, and all that, they are treated pretty much like anyone else. They'd still be subject to mandatory retirement. They would still be exempted to age 60 by an agency head. They could be exempted beyond 60 by executive order. So they're still essentially a law enforcement official.
What happens when an employee is employed as a 1811, but the special retirement is not coded?
So if it's not coded, I assume you mean then therefore the proper retirement deductions weren't withheld either. Okay, so if the position should have been, if it was an approved position and it was not quote unquote covered by administrative error, they would have to go back and get that extra 0.5%. They would have to correct the records retroactive. And again, this isn't FERCA. This is just a mandatory correction. So the person met all the criteria, was in a covered position, met all the criteria to be in that covered position, including any FERS transfer requirements, and just for whatever reason it was incorrectly coded in on the SF50, and then therefore the wrong percentage of retirement deductions was held. They would have to correct all of that and then submit that additional 0.5% of retirement contributions. They'd have to do that before we could even adjudicate a claim.
This next question is asking if the absence of a RI 20-124 from a retirement package would be an error in the retirement audit.
Boy, you just can't get away from the audit questions, can you? Yes, it would. I think there's an actual error for not having the proper certification there. I know there's an error for not indicating it, for instance, so I'm sure that an error would be charged if the certification wasn't included. Again, the package, without the certification, package is incomplete, can't be adjudicated. And that's what the audit's all about. Don't be making up questions now.
No, I just had to. Everything comes in this box. I had to skip the ones that weren't LEOs.
Gotcha.
You discussed what happens when a LEO/firefighter retires. What happens if the LEO firefighter doesn't meet the retirement requirements? Presently, the extra 0.5 withholding is not refunded to the employee. Is there anything planned to refund this money to employees?
No, not that because the extra 0.5% is required for the position. and it's not tied into whether the person ever ultimately receives the enhanced benefit or not, the extra 0.5% is required for the position by law. So if an employee were to separate without having 20, if they were separate for retirement, for instance, without having the 20 years, maybe they met requirements for an MRA and just said enough's enough, I don't have 20 years yet, but I'm not waiting around. So no, they wouldn't be eligible for the computation, and they would not get the special 0.5% additional retirement contribution back. And I know of no plans to change that.
If an employee transferred to another agency prior to the creation of the 20-124 in 2012, who's responsible for completing it?
The current agency is always responsible to certify eligibility for a special retirement. So they would have to be able to make the determination from all the official records in the OPF. That's why we say that the position description, any coverage determinations made, qualifications, etc., has to be in the OPF. A person should be able to audit an OPF and determine from all of the evidence in the OPF that a person qualified for special retirement, and they should be able to verify whether the 0.5% was withheld. Okay, so if the OPF's been properly documented, then they should be able to do it. There are some instances, for instance, Customs Border Protection officers that only CBP can do the certification, or there's also a corporation that's tied in with them can make the decision. And if a person had that CBPO service in their history that was qualifying them for a law enforcement firefight official, they may have to go back to Customs and Border Protection to get that certification. And if I would say this as well, if there is insufficient evidence, in their opinion, in that OPF to make the decision, they could go back to the other agency and request assistance.
Is AUO earned by a non-LEO employee used in the High 3?
Anything that's included in base pay and has retirement deductions withheld from it is included. So if they're receiving that if they're receiving additional premium pay like that for their position, yes, it would be included.
If I was in a primary position that was subject to or included or approved LWOP for a substantial period of time in the year, wow, okay, 6 months annually, any of the LWOP time applied is established the required 3 years. Okay, basically they're saying.
Yes, I know what they're getting at. In other words, if you're on a leave without pay for a whole year, you're going to get credit for a whole year for meeting the 3-year transfer requirement. The answer is no. You would get credit for up to 6 months of the leave without pay. Same thing for credit for the service. I mean, it's the same thing as crediting service, essentially.
On the certification requirement slide, is the RI 20-124 form submitted to OPM with all the other certifications in the event of retirement or death? The slide says in the event of retirement.
Well, there was a previous slide, however, that said the RI 20-124 is required for any separation now. And that would be just someone who just separates, resigns, is terminated, whatever it is. And again, the reason's sort of twofold that we want those certifications even for a non-retirement or non-death related separation. It's because of that enhanced benefit largely because of the enhanced benefit for disability and for survivors, and that we need those certifications for sure now, but also I think it also helps in other cases where perhaps the certification was difficult to make because of maybe evidence lacking in the OPF. Now if you have the certification form for every separation, and obviously it just started in 2012, so you know we're talking about 20 years going forward from 2012, but it's obviously going to help. in making certifications for regular law enforcement and firefighter retirements.
Is it possible to get an extension so one doesn't have to retire at age 57? This is in regard to a secondary position.
Okay, so the question was asked, can you get an extension? Well, yes, we talked about in one of the slides, we talked about being exempted from mandatory retirement. The agency head or their designee can exempt you from mandatory retirement up till age 60. If you're 57 with 20. Now if you're age 57 and don't have 20 years of approved law enforcement or firefighter or any of those combinations, you're not subject to mandatory retirement until you are both at least 57 and have age 20 years of service. And I spoke with a group of, for the Atlanta Inspector General Council a couple weeks ago. And this question came up a bit. And we talked about the fact how someone can almost exempt themselves from mandatory retirement by leaving an approved firefighting position. So someone who wants to extend their career beyond their mandatory retirement age can essentially do so by either being exempted, okay, by the agency head up to age 60 under FERS, or by finding a position outside of the law enforcement or firefighter field, okay, and just going to regular employment. Because remember, to get the benefit, you don't have to be in the position. You only have to have already met 20 years of covered special service and be at least 50. So you can leave firefighter or law enforcement covered position at age 55, for instance, and work for 10 more years if you want to. You're not going to be subject to mandatory retirement at age 57 because you're no longer in an approved position, okay? So, but if you're in that approved position, once you've hit 57 and 20, the only way you can be exempted is from the agency head up to age 60, and after age 60, it requires an executive order.
Regarding the FERS non-deduction service, if the employee makes a deposit equal to 1.3% of basic pay, does the employee have to pay back the additional 0.5% that's contributed biweekly in retirement deductions?
Okay, so on a deposit case, we can only charge the deposit that's required by law. And under FERS, for pre-89 service, except for those two, and right now we're not talking about the two exceptions. Right now we're talking about regular non-deduction service or service under another retirement system other than foreign service pension system or Federal Reserve Bank plan. You have to pay the required FERS deposit. It's 1.3%. There's no requirement that we get the extra 0.5% because it's not service that is subject to retirement and therefore subject to the mandatory extra 0.5%. Now, if it's service under the bank plan or the Federal Reserve Bank plan or under the Foreign Service Pension System, then it requires the current deduction for the position, which would be 1.3%, even though the current deposit for any other employee that was not under for law enforcement or firefighter would only be 0.8% for a bank plan or Foreign Service Pension System.
Are there any special provisions for firefighter law enforcement employees to pay deposits for temporary time after 1/1/1989?
Only the two I mentioned, and that would be if you were performing service creditable under the bank plan, and it happened to be qualifying service, meet the qualifications for law enforcement or firefighter, which I think under the Federal Reserve or Bank. I don't think they have firefighters, but they may have law enforcement officials, or under SPS, the Foreign Service Pension System, their FERS equivalent. Those are the only two times you can get credit for service, non-FERS service, after 12/31/1988. And some VA nurses, but they wouldn't be qualifying for law enforcement.
Will an LEO keep his 1.7% calculation if he leaves a special retirement coverage after completing 20 years of law enforcement coverage and decides to work in a different FERS-covered career field?
Yes, we've mentioned that a couple times now, and it was in the slides. So essentially, to get the special computation, you do not have to separate from a special covered position. You just have to have the 20 years of FERS special covered service and be at least age 50.
Can you provide the statutory basis or other reference that supports the use of AUO in a non-LEO employee's high 3?
Not sitting here on camera, I can't, but I will try to find them and put them in the Q&A document. Guess I could have used my phone. Need some background music while this is going.
If an agency is requesting an age waiver to... Okay. If an agency is requesting an age waiver to hire/convert already hired positions from a secondary coverage to primary coverage from the agency head, does a 6-month requirement to request primary coverage get waived because the agency is now trying to convert all non-supervisory 8111s to primary covered positions?
Ooh, I deferred on that one earlier, and I'm going to defer again because I think I'd probably actually want to have more information, because clearly the question that's being answered is about something specifically that's happened. And I think I'd actually like the individual, anyone involved with this particular question to kind of send us some background information. It's kind of hard to make an answer on something this specific without seeing everything that's behind it. So I'm going to ask the person that made the first question that I deferred on about this, and then this follow-up question that I'm deferring on. I'd actually like to request additional information. So if you could please send that additional information to benefits@opm.gov and reference this specific question, then we'll make sure it gets to me, and then it'll help me give you a proper answer. But I got a feeling something very specific's going on here, and I don't think I want to wade into it without knowing all the background.
Can an LEO, when they retire, be able to draw from their TSP, or do they have to wait until age 59 and a half to withdraw?
I don't think it's in my purview to answer that question. I think that question should be directed to the Thrift Savings Board.
Can you clarify for the audience that an employee can serve in an approved LEO position such as a 1811 and not be covered by a special retirement because the transfer requirements were not met?
Yeah, so if you were in an 1811 position, secondary position now we're talking about, if you did not meet the FERS transfer requirement, you'd be in the position, but you wouldn't be under the special coverage. That could happen because you qualified for the position based on military experience. It could be because you qualified for this position based on other civilian service, not federal. Or it could be that you qualified for you got into the position after only being under a primary position, say for a year or two. So again, if you don't meet the transfer requirement, you can be eligible for the position and be in the position without having the special coverage designation.
This is the last one up currently. Once a person has 20 years and they go out and they go to a non-LEO position, do they still pay the higher retirement contribution?
That's a good question. No, they do not. So the percentage of pay you pay for retirement is based on the position you occupy. Okay, so when you're occupying and that's why you pay an extra 0.5% if you were to be occupying a position without the coverage, say as a reemployed annuitant. Okay, well the same holds true. The fact that you now have the special coverage entitlement, or the marker for it, say waiting to be age 50 and you're in a non-covered position, or if you just moved after that having your time because you didn't want to be subject to mandatory, you're going to be subject to whatever the withholding rate for the position you occupy is. So if you're just, let's say you moved and became a human resources specialist, well then you'd be paying 0.8% under FERS, whether you're no longer in a covered position. So no, you don't have to keep paying the higher percentage rate. Well, that's all the questions we have for today. So I will put out the Q&A document. It'll get attached to the webinar presentation, and the webinar, when we post it on our website, I will handle the questions that I had to defer. I'd like to remind the individuals with the question about the retroactive group adjustment to 1811s. I'd like to see the background for that. I really don't think that's an appropriate question to answer without the background. And I want to thank everyone for tuning in today. I hope it was informative. I hope I answered your questions. And again, we'll answer any questions that come in after I finish here in a few seconds. We'll handle those in the Q&A document as well. Again, thank you very much and have a great rest of your day.